Hello viewers, in this lesson we will learn about the features and operation of the collective investment schemes. Objectives: to learn about the meaning, significance and modus operandi of the collective investment schemes. To learn about the collective investment scheme trust. To learn about winding up the schemes and other related matters. This lesson explains the various issues relating to the collective investment schemes. Viewers, now we will learn about the meaning, significance and modus operandi of the collective investment schemes. Meaning and significance. Collective investment scheme is a scheme based on a trust which comprises a pool of assets managed by a collective investment scheme manager and is governed by the collective investment schemes regulations issued by the Securities and Exchange Board of India. These schemes have become very popular investment schemes in this century. In this scheme, each investor has a proportional stake based on his contribution of investment. To manage the investment in the scheme, a trust has to be created which functions as a financial instrument. Through the trust, the financial experts invest the money on behalf of the investor of the scheme. The collective investment scheme, in short called CIS, provides a relatively secure means of investing on the stock exchange and other financial instruments. The amount of money that is exchanged on the stock exchange and in the money market make them too pricey for majority of investors. Through this scheme, the money from the investors is pooled or collected together to form a scheme portfolio. This CIS is referred to in the Securities and Exchange Board of India Act 1992 and also in the Securities Contracts Regulation Act 1956. Through the Securities Laws Amendment Act 1999, which forms the legal basis for this CIS. This scheme plays a very significant role in providing a secure means of investments. Definition: according to Clause BA to subsection 1 of Section 2 of the SEBI Act 1992, collective investment scheme means any scheme or arrangement which satisfies the conditions specified in Section 11AA. Subsection 1 to Section 11AA provides that any scheme or arrangement which satisfies the conditions referred to in subsection 2 or subsection 2A shall be a collective investment scheme. This section further states that any pooling of funds under any scheme or arrangement which is not registered with the board or is not covered under subsection 3 involving a corpus amount of 100 crore rupees or more shall be deemed to be a collective investment scheme. Subsection 2 lays down that any scheme or arrangement made or offered by any person under which the contributions or payments made by the investors by whatever name called are pooled and utilized for the purposes of the scheme or arrangement. The contributions or payments are made to such scheme or arrangement by the investors with a view to receive profits, income, produce or property, whether movable or immovable, from such scheme or arrangement. The property, contribution or investment forming part of scheme or arrangement, whether identifiable or not, is managed on behalf of the investors. The investors do not have day-to-day control over the management and operation of the scheme or arrangement. Subsection 2A provides that any scheme or arrangement made or offered by any person satisfying the conditions as may be specified in accordance with the regulations made under this Act is a CIS. Under subsection 3, the schemes or arrangements which do not amount to a CIS are narrated. Under this provision, notwithstanding anything contained in subsection 2 or subsection 2A, any scheme or arrangement made or offered by a cooperative society registered under the Cooperative Societies Act 1912 or a society being a society registered or deemed to be registered under any law relating to cooperative societies for the time being in force in any state, under which deposits are accepted by non-banking financial companies as defined in clause F of section 45I of the Reserve Bank of India Act 1934, being a contract of insurance to which the Insurance Act 1938 applies. Providing for any scheme, pension scheme or the insurance scheme framed under the Employees Provident Fund and Miscellaneous Provisions Act 1952, under which deposits are accepted under section 74 of the Companies Act 2013, under which deposits are accepted by a company declared as a Nidhi or a mutual benefit society under section 406 of the Companies Act 2013. Falling within the meaning of chit business as defined in clause D of section 2 of the Chit Fund Act 1982, under which contributions made are in the nature of subscription to a mutual fund. Such other scheme or arrangement which the central government may, in consultation with the board, notify shall not be a collective investment scheme. Under subclause IB2, clause H of section 2 of the Securities Contracts Regulation Act 1956, securities include units or any other instrument issued by any collective investment scheme to the investors in such schemes. Thus, the CIS also is called as a security. Modus operandi. The CIS must be operated through a collective investment management company, in short called CIMC. The SEBI Collective Investment Schemes Regulations 1999 govern the launching and carrying the CIS. Under these regulations, CIMC means a company incorporated under Companies Act 2013 and registered with SEBI under these regulations, whose object is to organize, operate and manage a collective investment scheme. Further, under these regulations, no person other than a collective investment management company which has obtained a certificate under the regulations should carry on or sponsor or launch a collective investment scheme. The SEBI is the registering authority. The procedure for registration is stated in the regulations. Under the regulations, the following eligibility criteria is stipulated for registration with SEBI. The applicant is a company registered under the Companies Act 2013 with one of its main objects as managing of CIS in the Memorandum of Association. The applicant has a net worth of not less than rupees 5 crores. The applicant has adequate infrastructure to operate CIS. The directors or key personnel of the applicant must be persons of honesty and integrity and also must have adequate professional experience in related field and have not been convicted for any offense involving moral turpitude or for any economic offense or for the violation of any securities laws. At least 50% of the directors of the company shall consist of independent directors. No person, directly or indirectly, connected with the applicant has in a past been refused registration by SEBI. At least one of the directors of the applicant company who is not subject to retirement is a representative of the trustee. The applicant company is not a trustee of any CIS. Under the regulations, the SEBI may grant a certificate of registration to the applicant company subject to fulfillment of the terms and conditions thereon, which are imposed in the interest of investors. The important conditions are as follows. Any director of the applicant company should not be a director in any other CIMC unless such person is an independent director and approval of the board of CIMC, of which such person is an independent director, has been obtained. The applicant company should forthwith inform SEBI of any material change in the information or particulars previously furnished, which have a bearing on the certificate granted by it. Appointment of a director of the company must have prior approval of the trustees. Any change in the controlling interest of the applicant shall be made only with prior approval of SEBI. The trustees and the unit holders holding at least one half of the nominal value of the unit capital of the scheme. The company should take adequate steps to redress the grievances of the investors within 1 month from the date of receipt of the complaint. Rejection of registration. The SEBI can reject an application for registration if it is not satisfied with the furnishing of details on the application, but it should give a reasonable opportunity to the applicant to present its case. That means a fair hearing must be given. The decision of rejection should be communicated to the applicant by SEBI within 30 days of such a decision, and the SEBI must state the grounds on which the application has been rejected. Legal obligations of CIMC under the regulations. 1. The company should not undertake any activity other than that of managing the scheme. It should not act as a trustee of any scheme. It should not launch any scheme for the purpose of investing in securities. It should not invest in any schemes floated by it. However, the company may invest in its own scheme subject to the condition that it shall make disclosure of its intention to invest in the offer document of the scheme, and it shall not charge any fees on its investment in that scheme. The company shall be responsible for managing the funds or properties of the scheme. The company must ensure that the scheme is managed in accordance with the provisions of the regulations, the offer document, and the trust deed. The company is responsible for the acts of commissions and omissions by its employees or the persons whose services have been availed by it. The company must appoint registrar and share transfer agents and must abide by the code of conduct as specified in the 3rd schedule. The company must furnish the reports of the receipts and the payments in its activities, the balance sheet, profit and loss account, and the status of compliance of SEBI regulations to SEBI and also the trustees and unit holders. Viewers, now we will learn about the collective investment scheme trust. The collective investment scheme must be constituted in the form of a trust. The trust is formed with a trust deed which should be registered in accordance with the provisions of the Indian Registration Act 1908. The trust deed must be executed by the company in favor of the trustees. The SEBI Debenture Trustee Regulations 1993 govern the trust. Under the regulations, the trustees hold the assets of the scheme for the benefit of the unit holders. Further, the trust deed must contain such clauses as are necessary for safeguarding the interests of the unit holders. The regulations prohibit the insertion of any clause which has the effect of limiting or extinguishing the obligations and liabilities of the CIMC in relation to any scheme or the unit holders, or indemnifying the trustee or the company for loss or damage caused to the unit holders by their acts of negligence or acts of commissions or omissions. Thus, a lot of safeguards are prescribed for protecting the interest of the investors. Qualifications for trustees. Under the regulations, the persons registered with SEBI as debenture trustees are only eligible to be appointed as trustees of collective investment schemes. Further, no person is eligible to be appointed as a trustee if he is directly or indirectly associated with the persons who have control over the CIMC. The company must furnish to SEBI the particulars of trustees appointed. The regulations prohibit the appointed of such persons as trustees if they have been found guilty of an offence under the securities laws or SEBI or any authority to which SEBI has delegated its powers has passed against such persons an order under the Act for violation of any provision of the Act or of regulations made thereunder. The regulations require the trustee and the company to enter into an agreement for managing the scheme's property. Rights and obligations of the trustees. The regulations stipulated several rights and obligations on the trustees to safeguard the interest of the investors. Rights. The trustees have a right to call for any information from the company. They have a right to inspect the books of accounts and other records. They can do all the needful to safeguard the interest of the investors as directed under the regulations. Obligations. 1. The trustees must ensure that the company has the necessary office infrastructure. They should ensure that qualified key personnel are appointed in the company. They should ensure that the company shall comply with the provisions of the Act and the regulations and the trust deed. They should ensure that the grievances of the investors are redressed. They should ensure that the company has made adequate insurance coverage for the assets of the scheme. They should ensure the minimum net worth by the company on a continuous basis. They must cause the audit of the annual accounts by an auditor empaneled with SEBI. Also, each scheme must be caused to be appraised by an appraising agency. And further, the scheme must be rated by a credit rating agency. They should bring to the notice of SEBI any violations by the company, any acts of commissions and omissions, immediately on coming to know about them. Termination of trusteeship. Under the regulations, the trusteeship of a trustee shall come to an end under the following circumstances. The trustee ceases to be the trustee as provided under the SEBI Debenture Trustees Regulations 1993. The trustee is being wound up. The unit holders with 3/4 majority pass a resolution for removing the trustee, and the SEBI approves such a resolution. SEBI has decided to remove the trustee for any violation of the Act or the regulations. The trustees express their intention of not to continue as trustees by issuing 3 months' notice. In such case of termination, the company shall appoint another trustee within 3 months from the date of such termination. If it fails to do so, the SEBI can appoint a trustee. Termination of the agreement. Under the regulations, the agreement entered into by the trustees with the company may be terminated in the event of the company is in the course of being wound up or with the unit holders pass a resolution to terminate the agreement with 3/4 majority and obtains prior approval from the SEBI or in the interest of the unit holders, SEBI or the trustee with prior approval of the SEBI decides to terminate the agreement. If the agreement is terminated, another CIMC registered with SEBI must be appointed within 3 months from the date of termination. If none of the CIMC registered under the regulations consent to be appointed as the CIMC within a period of 3 months, then the trustees may wind up the scheme. Viewers, we will now learn about the winding up of the scheme and other related matters. SEBI Collective Investment Schemes Regulations 1999 contain the provisions on the winding up of the CIS. Normally, the scheme shall be wound up on the expiry of duration specified in the scheme or on the accomplishment of the objective of the scheme as specified in the offer document. The scheme also can be wound up under the following circumstances. The trustees are of the opinion that due to the happening of an event, the scheme must be wound up and they obtain prior approval of the SEBI. The unit holders pass a resolution for winding up of the scheme with 3/4 majority. The SEBI opines that the continuance of the scheme is prejudicial to the interest of the unit holders. The CIMC is of the opinion that the purpose of the scheme cannot be accomplished, and in this regard, the trustees and unit holders with 3/4 majority passed a resolution to wind up the scheme, and further, the prior approval of SEBI is obtained. The trustees, before winding up the scheme, must give a notice disclosing the circumstances under which it is decided to wind up the scheme in a daily newspaper having nationwide circulation and also in a newspaper published in the language of the region where the CIMC is registered. The assets of the scheme must be disposed of by the trustees in the best interest of the unit holders, and the proceeds must be first utilized towards the discharge of the liabilities which are due and payable under the scheme, and after making appropriate provision for meeting the expenses connected with such winding up. Finally, the balance remains must be paid to the unit holders in proportion to their unit holding. Further, a report in this regard and a certificate from the auditors must be furnished to the SEBI and the unit holders. In case of any unclaimed money, it should be kept separately in a bank account by the trustees for a period of 3 years for the purpose of meeting investors' claims, and thereafter it should be transferred to Investor Protection Fund as may be specified by SEBI. It is very pertinent to note that under the regulations, on and from the date of publication of notice, the trustee or the CIMC, as the case may be, shall cease to carry on any business activities in respect of the scheme so wound up. The regulations also contain various provisions on the procedure for launching of the schemes, the details to be disclosed in the offer document, allotment of units and refunds of money, unit certificate, transfer of units investment, and segregation of fund and the listing of schemes. The students are advised to thoroughly study the SEBI CIS Regulations 1999, SEBI Debenture Trustee Regulations 1993, and Section 11AA of the SEBI Act, along with the related amendments, rules, circulars, guidelines issued by the SEBI and other authorities from time to time. Well, viewers, I hope you have enjoyed the lesson. We will meet again. Thank you.